we are in. So thank you so much, Karan Bhagiji. Having said that, I think henceforth, what do we do next as
Yeah.
members of, as citizens of this nation, and as members of the various organizations? I think we should take up activities to ask the government to revoke this these three
Yeah.
laws and pass it only after debate in the parliament.
Yeah,
So
yeah,
that
yeah.
is
We
my
have to
humble
discuss
suggestion.
Parliament. And some opposition party also should move to discuss on this say section-wise discussion or any other additional topic should be included like this. Okay. Please
Absolutely.
carry on.
The law should be passed only with discussion and debate, every
Yeah.
section wise. Yes.
Yeah.
Thank you so much, Tarun Bhagji. Our next speaker, Advocate Jacob Puducherry from Thrissur Court. Please. Thank you.
Hello.
Yes, yes, go ahead.
Yes. Okay, my dear friends and my advocate friends said about the merits and demerits of this code. I would like to say something about the previous law, IPC. The Indian Penal Code, IPC, was the official criminal code in the Republic of India, inherited from British India. This already said. The code was drafted on the recommendations of the first Law Commission of India. Law Commission established in 1834 under the chairmanship of Thomas Babington Macaulay. Code came into force in 1862. See, in Malayalam we say Macaulay Sahib, who was the chairman of the Law Commission at that time. The IPC was amended several times. Several times IPC amended. But IPC replaced after 160 years, 162 years now. Here there are the three, we know that main criminal laws, Bharatiya Nyaya Sanhita, IPC, established in 1860, Bharatiya Nagarika Suraksha Sanhita, CRPC, 1973, Bharatiya Sakshya Adhiniyam, Evidence Act, 1872. The three laws. Once I want to say something about in Malayalam. Mr. Lakshmanan will translate the matter. I see. Here, Bharatiya Nyaya replaced the Indian Penal Code, IPC, Code of Criminal Procedure, already said that in 1973, Indian Evidence Act 1872, and IPC. Also, here are some changes in sections. BNS, murder, 302 changed to 103 in BNS, theft 379 changed to 303, kidnapping 363 to 137. Section 420 of the IPC replaced section 318. There are in 511 sections in IPC. Now it is 356 sections. In IPC, 14 sections replaced and removed in the Sanhita. Here the question is, 406 IPC liable or not? Under the Indian law, 406 IPC is a non-bailable offense, meaning the accused cannot claim bail as a matter of right. This is the now in the new law discuss about it. and see something I have written. I have written in Malayalam. ഇന്ത്യയിൽ ക്രിമിനൽ കുറ്റങ്ങൾ ചെയ്യുന്നവർക്ക് നൽകപ്പെടുന്ന ശിക്ഷകളെ പറ്റി പ്രതിപാദിക്കുന്ന നിയമസംഹിത. ഇന്ത്യക്ക് പൊതുവായി ഒരു ശിക്ഷാ നിയമം ആവശ്യമായതിനാൽ ഒരു പബ്ലിക് നിയമമാക്കപ്പെട്ട ഒരു കൂട്ടം നിയമങ്ങൾ അടങ്ങിയതാണ് ഇന്ത്യൻ ശിക്ഷാ നിയമങ്ങൾ. ഇറ്റ് ഈസ് എ ബണ്ടിൽ ഓഫ് ലോസ് ഇൻക്ലൂഡിങ് 1860 IPC. ഇതിന്റെ പരിധി ഇന്ത്യ മുഴുവനും ജമ്മു കാശ്മീർ സംസ്ഥാനം ഒഴികെ ഇന്ത്യൻ മുഴുവൻ ബാധകമായിരിക്കുകയും ചെയ്യുന്നു. ഇന്ത്യ മുഴുവനും, ജമ്മു കാശ്മീർ എക്സെപ്റ്റ് ജമ്മു കാശ്മീർ. നൗ ദ ന്യൂ ലോ ഓൾ ഓവർ ഇന്ത്യ. ഇന്ത്യക്കുള്ളിൽ പ്രവർത്തിച്ച് കുറ്റക്കാരനാകുന്നു ഏതൊരു വ്യക്തിയെയും ഈ നിയമത്തിന്റെ വ്യവസ്ഥകൾ അനുസരിച്ച് ശിക്ഷാർഹനായി തീരുന്നതും ആണ്. In India, any person under ഈ നിയമത്തിന്റെ വ്യവസ്ഥകളിൽ ശിക്ഷാർഹനായി തീർന്ന. അതുപോലെ തന്നെ any foreigner in India who committed any crime, he is also liable to bear the punishment. ഈ നിയമം ബാധകമാണ്. In Germany, France, Italy, Japan, in all those countries, ഇതുപോലെ this penal കോഡുകൾ now existing there, but England there is no written penal code or something, some code of like that. ഓരോ കുറ്റത്തിനും ഓരോ പാർലമെന്ററി നിയമം ഉണ്ട്, ആക്ട് ഓഫ് പാർലമെന്റ് ഉണ്ടായിരിക്കും. ഇൻ എവറി ക്രൈം ദർ ഈസ് എ പാർലമെന്ററി ആക്ട് ഓഫ് പാർലമെന്റ്. ദർ വിൽ ബി എ ആക്ട് ഓഫ് പാർലമെന്റ്. ജസ്റ്റ് ലൈക്ക് മോഷണം, തെഫ്റ്റ്, ലാർസിനി ആക്ട്, കള്ളപ്രമാണം സൃഷ്ടിക്കൽ, ഫോർജറി ആക്ട്, കള്ളമൊഴി പറയുന്നതിനുള്ള പെർജറി ആക്ട്, പുനർവിവാഹം തുടങ്ങിയ അനാചാരങ്ങൾക്ക് ഒഫൻസ് അഗെയിൻസ്റ്റ് പേഴ്സൺ ആക്ട്, ഒഫൻസസ് അഗെയിൻസ്റ്റ് ദ പേഴ്സൺ ആക്ട്. There are certain related acts are also in this penal code. We can see, but I have to say talk about in Malayalam only some broadly, but I am not particularly, I have not here, I have not prepared something to say widely, therefore I am stopping here. Thank you.
Thank you, Jacob sir, for communicating that. Only in the mother tongue we will be in a better position to express ourselves. So if we had a translator, we will have another session in Malayalam in the with the translator, and we will take it forward. Thank you so much. So broadly we can see that the personal liberty of the individual, the citizen, is being curtailed in these three laws, and the way in which the laws have been passed, they are with an ulterior motive and they are unconstitutional. So these are the major takeaways that we can get from even the little discussion that we are having. Then I would very quickly summarize, give my views on this as a fourth and last speaker, as an advocate. Very bluntly, if the satyagraha for all the 22 languages of the Schedule 8 of the Constitution of India to be equally official languages in the high courts of India, if that satyagraha would have happened after July 1st, then Kelmurugan sir, myself, and the 24 others and more, we would be in jail. It is as simple as that. Even questioning the policy of the government can be read as against the sovereignty of India, and you could be put in jail. It is as simple as that. The individual's rights and liberty are at stake. And it is our duty as citizens of India, as human beings, to raise our voices, to raise questions against these colonial laws, against these fascist amendments to these laws. So having said that, the floor is open to questions from all citizens, advocates alike.
I would like to ask Advocate Murugan, sir, you said that 2 sets of laws are in operation. So when will this state of 2 laws, 2 sets of laws, when will it come to an end?
Mute, Murugan sir, mute.
Two laws, what is the political right and or old law or new law? I want to some clarity on that.
The question is, now parallelly 2 laws are being
Yes,
in
yes.
force.
Yes.
So when will this come to end? When the last
maybe
case,
the 2 process is going on more than 20 years. As per in the World Act, nearly up to 1976, even after the amendment of Act of 20 years before 1956, for a long time period of 20 years, the 2 parallel laws are already gone in the previous enactment. The same process may be happen this act also, because for the old laws, up to the appeal to Supreme Court, the old procedure will be continued. For the new laws, the new procedure is continuing from this July 1st onwards. So it cannot be said is some short period, that is 1 or 2 years, it may be changed. Maybe nearly 20 years may be gone. But within this, so many confusions will be arise and nothing will be decided in the lower court. Lower court has no capacity to handle the 2 procedures. So this will cause a serious confusions and also lead to a serious incapacity in the judiciary system.
Adding to what Advocate Murugan sir had said, the criminal appeal, if it is made after July 1st, then that would come under the new law. That is the confusion that has already been created. Because the wording of the new law it says that the appeal has to be under the new law. And that is the confusion. The judiciary is now split on this, as exactly what Murugan sir said. And this has to be decided by the Supreme Court only now. This has to be clarified or read down by the Supreme Court now. So we are going to have confusion for the coming years.
தமிழ்ல ஒரு படத்துல பரோட்டா சூரி கதை மாதிரி தான், எல்லா ஆட்டத்தையும் கோடியும் அழிச்சிட்டு திரும்பி ஃபர்ஸ்ட்ல இருந்து பரோட்டா சாப்பிடுற மாதிரி.
Advocate Murugan is referring, drawing reference to a comedy scene in a Tamil film where the comedian, he says, no, rub out all the lines, we'll start from the beginning. So it's like that, you clean out all the cases and then we'll start from the beginning. So it's impossible.
The second question, Advocate Murugan, is that all the constitutionality of the 3 laws has been challenged in the Supreme Court. Am I right?
Yes, some of the petitions are already prematurely dismissed. Now, again, it starts from the beginning. All the constitutional already decided matters and all the rights which is decided in the old laws is again arise and also is come before the Supreme Court again. Definitely.
So till the constitutionality is decided by the Supreme Court, the operation of the new law should be suspended, no?
Yes, generally it should be a right one. Generally it should be done, but Supreme Court normally is not doing that. Why? Because is simply saying that it is a decision of policy decision matter. And also this act also decided by the central government on the enacted in the parliamentary, it cannot be questioned until it is decided by the people. People only raise the voice in so many cases in the Supreme Court. They tell, even in the Ayodhya cases itself, the voice is larger, then it will be considered in the Supreme Court. When the voice is very low, then it is not considered in the Supreme Court.
Thank you very much, Advocate Murugan.
Maybe we can follow it up. A new case can be filed, or the existing cases can be supported by our voice, our humanist voice. So that is.
One.
I have a question. What is the legal or rather social way of opposing these laws? And how can we safeguard common men to protect themselves? Because if the way they are explained right now, it appears that our protest also you cannot do. Normal protest also means you are an offender. So then that means these laws are opposing the basic freedom of right. I mean, the freedom of people to express themselves.
Yes.
ஐயா சமூக ரீதியாகவும் சட்ட ரீதியாகவும் நாம இப்போ குடிமக்களாக என்ன பண்ண முடியும் அப்படின்னு கேக்குறாருங்க.
Yes. You rightly say that. Already the bunds and strikes are also declared as unconstitutional. Now, the hunger strikes also declared as a criminal one. This is the main aspect. You are clearly stated that. Yes, is correct. But the two approaches is that one is a legal approach, another one is a political approach. What the legal approach is that number of petitions to be filed in the high courts and Supreme Courts against this unconstitutionality of the. So we fight against even the laws in the larger mass in the political area. Without in the political arena, without fighting in the political arena, nothing could be solved.
Okay.
I will just add to Advocate Murugan's statement. We have to file cases in the High Court and Supreme Courts for our fundamental rights. And Article 226 of the Constitution of India, it gives a wider power to the High Courts. And when an individual citizen approaches the High Courts for his fundamental rights, there he will have a remedy. Article 226 of the Constitution of India and the BNS new law, Section 226, it makes fasting, that is, curtailing the officer to do his duty by fasting. That is also a criminal offense.
Yes.
So it is
merely
very
blackmailing. Saying that blackmailing.
Yes, blackmailing with a hunger strike. Even our hunger strike is read as blackmailing the government, and you will be put in jail. And that section is Section 226 of BNS. So now it will be like Section 226 versus Article 226 in the High Court. So that is my observation.
Yeah. I would like to add another point.
Yes, sir, please.
Yeah. So I cannot see all these things. I'm in the dark place, and before that, I was not able to participate our my opponent's speech because due to my battery low. Then for the question, I would like to give the answer. That is we have to file the petition, as you said, as Mayapan said. We have to file the petition before the High Court and Supreme Court under this constitutional article number 226, and we can file the writ petition against the violation of the fundamental rights by these new laws. I think it will be getting the remedies. And we our Humanist Party and can approach to the Supreme Court or High Court and by filing the litigation. So this is we can do as an advocate or a practitioner, we can file without course also. And nowadays I'm planning to file many PILs before the Supreme Court and High Court in the interest of the people of Manipur and the people of India, citizen of India. So this is the right time. And if we file many cases, then our popularity of our party and the role and responsibility of our party will be recognized by the citizen or by the people of India. So I would like to get this chance. During the discussion also, we have to take this opportunity. Okay. So let's
Absolutely.
do. Yeah.
Absolutely.
This
I
thing
totally second your suggestion and proposal.
Yeah. Okay. Let us do it. Yeah.
Yes.
Later, this is Q&A session going on. So anybody has any question regarding these laws or the implementation of the laws, please ask our advocate friends.
If there are no further questions,
my question is,
yes,
it is about resisting these laws. So, what is the best forum for that? Is it through legal procedure or people's protest or parliamentary debate? So, which is the more effective option for this?
Shall I answer that question?
Yes, please.
Sir, it's all the three, but in this order. As individuals, we can only move the High Court or Supreme Court. I would suggest High Court is a better option. With
Yes.
our petition for the violation of our fundamental rights, specifically, whichever we would like to take up. And this would be supported by political activity, as our advocate Murugan sir had pointed out. The Supreme Court itself will consider something only when there is a political pressure in the.
Yeah, absolutely.
So these two will go hand in hand. And of course, if the Humanist Party of India has a member in the parliament to bring a independent bill or something, that would be even better, because I don't see the existing opposition parties doing anything, because they are hand in hand, they are hand in glove. So they will not, because they want a police state for going on with whatever they are doing. So I believe that third option is not in our hand. The first two options, that is, the first option is to file a petition in the High Court.
I add one point. The parliamentary, that is in the parliamentary, there is no chance of raising against this act. Why I am saying that? The big party, the Congress itself says, it's a copy and paste. He simply finished that act as copy and paste. This is not a copy and paste. Nearly 1/3 of the act is enacted as changed as a unconstitutional part as a one part of this section. In each and every act, BNS, BNSS, and BSA, in all the acts, the unconstitutional sections are added. But the big party, the Congress says, is a copy and paste. Another thing is regional parties. All the regional parties is one way is their ruling party, the DMK or Trinamool Congress or anything. We take it as it is a ruling party. This act is not implemented by the central itself, not by central itself. The state government also benefit on this, because there is no opposition. Take it as an example as in Tamil Nadu. Tamil Nadu, as in this DMK is ruling this state. It has no opposition. In BJP, central is ruling the India, but there is no opposition. In both the places, there is no opposition at all. Why this ruling party is willing this act? This is the main part. The crisis, which is the main part, each and every people. This is not happen in India, not in India itself. It all over the world, all the acts are changed in two aspects, in two conditions. One, for the new digitalized world, it wants to convert the new laws. And another one is, he want to overcome the crisis. It completely should write the black laws. Without black laws, no country can rule and overcome the crisis. In each and every country, in all the countries, the whole liberty laws are totally gone out, and new enactment laws are black laws. Based on the same thing, India also enacted this 3 criminal laws based on the same aspect. This crisis came only because of the globalization effect. Based on this, each and every state has no way except to oppress the people. Without oppressing the people, they cannot rule even in a state or in central. Hence, they have some understandings. They only write the letter to the center, not fight against the center. This is a two aspect. Simply file a petition or simply write a letter. None other than that, no action is taken by none of the state. It's a larger party, even in the regional parties, they can fight, means there is a changes may be possible. But it is not possible. Why I am saying it is not possible means this regional party itself wants this act. This is the message. We understand that we only peoples have the only courage and have the willing power to change all these act, all the black laws. What happened is, this criminal act is more dangerous than the UPA. That is the very unfortunate thing is, because in UPA, sanction is necessary, but in criminal act, for the terrorist act, no sanction is necessary. Where that sanction is necessary, but in the BNS act, no sanction is necessary. That means this is more dangerous than the UPA. And also, one person can be prosecuted in two aspects. The UPA, based on the UPA, NIA is prosecuting, and based on the Terrorist Act, the state government can prosecute. Based on this, two prosecutions may be possible, and there is a double jeopardy is there. But how it is handled in this case, I can't know, because this is the gray area where Terrorist Act can apply or UPA can be applied. This is all the gray areas where he can facing two aspects. That is, he facing the more dangerous than the UPA. This is the main aspect. Hence, I clearly say that the people are the only persons, people are the only last resort to change all the black laws, and they only gathered without any deviations and without any differentiation. If they only integrated, then only it can be possible to overthrow all the black laws. That's the one example is that the fighting against the what is the agriculture already the Peasants Act, where the peasants are all gathered in Delhi and fight against that act and overthrown that act. That is the main example that should be taken into consideration. And overall, in the area of the India, without any deviation and differentiation, they integrated means definitely we can overthrow these black laws.
Thank you. Thank you so much, sir.
Thank you.
Having said that, active non-violence
it is really shocking and surprising that even all the political parties are not opposing this. And it appears that the human rights, I mean, the basic human rights are all compromised here. So it's like this, that unlike Indian movies, villain is winning.
Yes. I will just add to one thing. Like Murugan sir said, there are two aspects why new laws are brought in. One, as if to digitize digital era, to address the digital era, and second, to take away all the liberties. Now, currently, digital statements are being taken, which means that my statement, which can be digitally recorded, it can be directly used as evidence. That is one good aspect. But just 1 week ago, there was a cyber crime in which my number was involved, allegedly involved, and someone from Mumbai, he called me and he asked me for a digital statement. So I thought, okay, since all these new laws are there, they are taking my digital statement for 2 hours. I was sitting and I was giving my statement, and it was recorded. And at the end of the statement, he said, I'm forwarding it to my superior officer. You are kept under arrest. I said, what? Over the phone, he's keeping me under arrest. I said, you do whatever you want. You send your police. I'm here only. You have my address. You have everything. You take me in. You can put me in jail. But I will go ahead. And then I made a complaint. I made a counter complaint, and I had to come out of it. Now, this digital statement, which could be used as evidence, now it is being used against you. They can remotely put you under arrest if it is misused. But then it did not happen because I don't know. I had raised my voice and it did not happen. But then they're threatening to put you under arrest over online.
No, also, Mayappan, one has to be very careful with such things because now there is a lot of cyber crime or frauds going on using.
Fraud.
It may not be really somebody who speaks to you as if he is from some police department. He may be totally a fraudster. So
Yes.
this possibility exists.
This is a highly possible that it is a scam, but I am pointing out that this is possible even in reality. This gray area can be used. This gray area of a what do you call digital statement. Your
Right.
statement can be used against
Right.
you.
Definitely,
So
this
Okay.
I think 1.5 hours
Yeah,
we have
1.5
had a very
hours.
meaningful discussion
Right.
and debate, and
Yeah.
you know, a possible way ahead forward together. We have to raise our voices in an active, non-violent manner. So I would like to thank all the speakers and all the participants for the valuable views, questions, and everything, including especially our advocate Murugan from Madras High Court, advocate Jacob sir from Thrissur, advocate Karun Bagji from Manipur, and all the participants of the Humanist Movement and Party. Thank you so much. I would like to give the floor to Ashutosh ji to formally give the vote of thanks. Thank you.
Thank you very much,
Yes, thank
Professor Advocate Mayappan. There are many times the experience that we have an interesting discussion and there everything ends. But in today's case, I think all the speakers have pointed out the need for all of us to act unitedly in opposing these draconian laws, and the adjectives used for these laws are draconian laws, black laws, fascist laws, and all these laws suggest that the state is trying to suppress the voice of the people. And the need to suppress the voice has arisen because people are opposing the policies. People are opposing the concentration of power and concentration of wealth. And people are opposing the fraudulent practices of the state. And this is a very, very strange situation which we are seeing. And as Advocate Murugan pointed out, the situation has come about because of the policies of globalization, privatization, and it has resulted in widening the gap between the people in power and the masses. So the ruling elites and the masses are now completely alienated, and that is the reason why the state feels the need all over the world, as Advocate Murugan has pointed out. And the only way forward is for people to come together and oppose it in an active but non-violent way. So I think the message is very loud and clear for us to act, and I hope all of us will be oriented in that direction. And we must thank our speakers, Advocate Murugan, Advocate Mayappan, Advocate Jacob, and Advocate Luan, and also all the participants who are here present today. So thank you very much. And let us end this with peace, force, and joy. Peace,
Peace,
force,
force, and joy to all.
to all.
Yes.
Thank you.
Thank you. Thank you.
நன்றி வணக்கம்.
Thank you. Good night.
ஐயா வணக்கம். நன்றி.